Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. If you've ever participated in mock trial before, you know that just about every witness has some kind of bad fact in their witness statement. Whether that fact reflects poorly on the witness character themselves, maybe some kind of bias, maybe some kind of thing they've done bad in the past, or just simply a bad fact that reflects poorly on the side of the case that witness is being called for. And so that leaves a lot of teams asking, well, what do I do with that? Do I just come up with an explanation on cross-examination and sort of throw the witness to the wolf? Do I make an objection? Do I try to keep that information out? Well, I wouldn't necessarily do either one of those things. Instead, I would do what we're going to talk about in this video. Because what we're about to go over is probably my favorite strategy for handling these types of bad facts or difficult questions that are going to be inevitable for a witness to deal with on cross-examination. And here's in order what we're about to go over. First, I'm going to tell you what the strategy is. Second, we're going to go over what not to do when you're executing this strategy. And third, we're going to go over what to do when you're using this strategy to, I think, probably send your performance to a new level in terms of your witness being comfortable on cross-examination and you as an attorney, what you're going to find out as we go over the strategy, getting a better score on your direct examination. Before we hop in though, I want to remind you that if there's any topic at all you want to see me cover on the channel, please leave a comment below. I make videos all the time based on comments and suggestions that you guys make in the comments and that you email to me, and I love nothing more than doing that because this channel is here for you guys. All right, ready to hop into this strategy that I think is going to make life a lot easier for you on cross-examination? Let's do it. All right, so here's the strategy. The name that I use for this strategy is called the soft cross. I've heard other people call this inoculation. For whatever reason, that to me sounds like giving someone a drug. So we're just going to go with soft cross on here. And here's what it means to soft cross a witness. When you soft cross a witness, you ask them a difficult question that they're likely to encounter on cross during their direct examination. That way you soften the blow of that question on cross and give them the opportunity to explain the situation with a friendly attorney standing in front of them. Now, you might hear that if you're hearing this for the first time and think, well, gee, why in the world would I ask my witness a question that makes them look bad on direct examination? Because again, like I just said, I promise a lot of the time when you do that, it will legitimately soften the blow. That's why we call it a soft cross of that question or of that topic when cross-examination rolls around. Now, when it comes to the soft cross, there is absolutely a right and a wrong way to do it. So first, to make sure you don't make any critical errors, let's go over the wrong way to soft cross. So some of the traps you want to avoid falling into if you're going to use this soft cross strategy are, first of all, trying to soft cross on everything. Right? This tends to work best if you're going to pick the biggest, worst, baddest fact that's going to go against your witness. And the reality is that not every so-called bad fact or item in your witness's statement that helps the other side is significant enough to use this strategy with. Some of that material you just need to leave for cross-examination and let your witness handle it. What we're talking about here, again, is the really bad stuff. The stuff that you look at and almost want to ask, should we even call this witness? So you want to ask the soft cross question on direct examination if you feel like not asking it would sort of leave your witness getting thrown to the wolves on cross. Otherwise, there's no need for this a lot of the times. But when the need arises, it can be a really, really effective strategy. Another trap that a lot of people fall into is giving really bad explanations. You want to explain the situation, certainly, but you want to take some time in advance of your tournament to think about the best way to explain the situation. Let me give you an example from my recent case. So we had a witness, a defendant, who denied making prank calls to the victim in this case leading up to this case. Well, when the police pulled this defendant's phone records, they found 10 phone calls from the defendant to this victim leading up to the incident that occurred. And so what we were left with as we were working with our witnesses who were playing this defendant is, how do we explain the fact that on one hand, she says, nope, didn't make any prank phone calls, and on the other hand, these phone records say she called him 10 times in 3 days, right? Just doesn't make any sense. So we've got to come up with some kind of explanation, and we've got to do it on direct examination to soften that blow on cross. The first explanation we thought of is that this witness, this defendant, called to apologize. There was an incident in the case where the defendant had done something to the victim of the case leading up, and we thought, well, maybe she called to apologize. But the more we thought about that, we thought, how corny does that sound? Imagine the cross-examining attorney, if we didn't use this soft cross strategy, getting up and asking the witness, now, you made 10 prank phone calls to this guy. No, they weren't prank phone calls. They weren't prank phone calls. No, I was calling to apologize. I just felt right. Cornball. Bad. What we landed on was an explanation that actually made the defendant look a little worse, but not like a liar. What we said was, yeah, I called him 10 times to remind him that he owed me money. Because there was this fact in the case where the defendant kind of was owed money by this person, and we made it work in that way. Now, he owed me money. You hear that and you're like, well, you're admitting to the fact that he was harassing the guy about owing him money? Well, yes, but it looked a whole lot better than the apology thing, which just frankly sounded like a flat-out lie. And it also looked a whole heck of a lot better than literally admitting to a lie and saying, yeah, you know what, guys, you got me. I did make the prank phone calls. Right? That's what you want to have with your explanations. You want to make them logical, and you don't want these sort of sappy explanations. Well, I'm just a good person, and I would never have, right? You don't want that sort of thing. One other trap to avoid is asking the home run question. Usually when I talk about home run questions, it's in relation to cross-examination. You never want to ask, you're biased, aren't you? Or something like that. You want to get up to that point but not actually ask it. When you're doing the soft cross strategy, you don't want to ask a home run question. So here's what that might look like. So let's say you're crossing an expert witness that has a little bit of bias in their background. Let's say it's a defense expert who is friends with the defendant. So you ask your expert witness in direct examination. You say, now, Dr. Whoever, just so that we can be transparent with everyone, can you tell us about your relationship with the defendant? Yes, I am friends with the defendant. That is true. And they stop there. Do not ask the follow-up of, but did you let that affect your investigation? And then the expert says, why, no, I did not. And then everyone's thinking, well, that seals it, folks. He said it didn't let him affect, right? It's stupid. Don't do that. So avoid these traps on your soft crosses, and it's going to make the strategy a lot more effective. Now, let's talk about what you should be doing on your soft cross. Before we wrap this up and talk about what your soft crosses should look like, I want to remind you that my book, Mock Trial Masterclass, covers everything you need to know about delivering a great direct examination and cross-examination as an attorney in mock trial. Quite frankly, I wish I had this guide when I got started in mock trial, because it took me way too long to learn a lot of these things. Well, I put them all into this guide so that you can have easy access to them, and you don't have to wait as long as I did or dig as hard as I did. It's all in one place for you. And if you want to pick up a copy, you can click the link in the description on YouTube or in the show notes if you're listening on podcast platforms. So when we start to think about what your soft cross should look like, really a lot of the shoulds flow pretty directly from a lot of the shouldn'ts. Instead of giving a bad explanation that looks like a lie, you want to give a reasonable one. Even if it makes your character, your witness that you're playing, look a little less than stellar, it still might be better than the alternative. So an answer that sounds legit, that sounds honest. You want to not, do this with every witness and do this with every fact, but instead do it with those facts that are going to keep your witness from looking like they were thrown to the wolves on cross-examination. Here's a good litmus test. if you're working with a witness as an attorney in mock trial, your teammate, and they're real nervous about this one point, and they're constantly asking, man, I'm real worried about getting asked about this thing on trial. Those are the types of questions, the types of issues you need to run this strategy with. That's going to give them a lot more peace of mind leading up to the competition. And once you put all of that together, this strategy works really, really well. Just make sure that as an attorney, you have a very comfortable tone, a very friendly tone. And as a witness, you're portraying it as a moment of honesty. You know, maybe you're talking about things you did in the past and you have a moment where you're like, you know what? I do have these things that I did in the past and I regret them. And it was a bad decision that I made. You know, doing it like that as opposed to, but I've changed and I've made a moral turnaround, right? If you kind of take it on the chin like that, it has a much better effect. So just keep all of this in mind and utilize this strategy if you have a chance to, because it really can work wonders for you and make life a whole lot easier for your witnesses at your next competition.